we'll give everyone an opportunity to come in before we start. So I'll welcome people as they come in, but we'll allow for a good majority to be here before we get us started. So one thing I asked our team to do, or our panelists rather, to do today is put in the company name next to their name as well, or company or law firm, and just so that gives further context as we're doing the session. We will be doing some introductions momentarily as well, so that'll give you the broader context, but as reminders, even the organizational names are right next to our names. I'm excited for this all-star panel. We had lots of good jokes and good stories to share here today. And one thing we realized pretty quickly is that there will be an encore to this, because there's no way we can cover everything we want to cover in one session. So as we'll realize pretty quickly, this will be like one of those stories that everyone waits for the next one, like the next episode on Netflix coming up.
To do like a monthly coffee chat over Zoom.
Yeah.
Multilingual litigation monthly.
And it evolves so quickly that there's probably monthly updates that could be given.
You heard it here first, folks.
Well, exactly. So everyone is getting sort of a first hint at it in the early stages. So what I'll do is, as people come in, I will start us with some just housekeeping items, and then we'll go to the introductions of the panel. So as housekeeping, the team here can ask questions. Any of the attendees can ask questions. Feel free to throw them in the chat as you see fit. What I will do is as we go throughout the session today, if some of the questions can be intertwined with where we are in the topic, we'll do them live. Otherwise, I'll try to do them at the very end before we wrap up. We may not get to all the questions, but the audience, every panelist has confirmed they're happy to chat with you offline on in more details for anything else that may come up. So without further ado, I will start with some introductions, and I will first introduce myself, and then I will pick on Corina first, Miriam, and then Sonali, just to go in alphabetical order. And then we'll switch it up when we go with the questions and answers earlier. And I know the topic to some people may sound a little dry, but I promise this is anything but dry. It'll be very exciting today. So with that, I will introduce myself. My name is Gary Kalazzi. I'm the CEO at Alexa Translations, a lawyer by training. So some of the war stories that will be shared here today, I can relate to, some more than others, but it's always a lot of fun. And we do a lot of webinars through Alexa Translation. We really try to add a lot of sort of context to our audience and value add with learnings from other partners and clients and friends of Alexa. So on that note, I will start with Corina, ask Corina Manole to introduce herself. And I said her name the proper Romanian way, because when you're in our business, you are supposed to say the names in the proper way. So Corina, on that note, I'll ask you to introduce yourself, please.
Thank you very much, Gary. It's a pleasure to be here today. My name is Corina Manole. I'm a senior associate in the Tories Montreal office, and I act in various litigation matters before civil and administrative tribunals in Quebec, and I deal with language-related challenges almost every day of the week.
Thank you, Corina. And just for background, Miriam and I are both in Toronto, but everyone else is, we're all in different locations in many ways. So Miriam, I'll ask you to introduce yourself next.
Hi, everyone. Even before I do that, I just want to say I'm looking through the attendee list, and I'm seeing so many of my language friends. I have two worlds. In fact, this webinar is my two worlds colliding in many ways, which is really great. So I'm you could say my day job is being an international disputes litigator. I was actually also at Tories for the majority of my career. in the Toronto office. However, Karina is in the Montreal office. And I left just about over a year ago to join an international disputes boutique, which is now called Agora. So that's what I'm doing now. But I also have a language company, so on the side, which started off as a side hustle, and now is a company. So I also do and revise legal translations into English, and obviously in my international disputes practice, pretty much every case involves language issues. So this is when you said that this webinar would be dry, Gary, it's like, but not for me. This would be anything but dry. But I do want to say hello to the folks that are attending that I know from my language world more than from my litigator world. It's very exciting to have you here. Thank you for making the time.
Thank you, Miriam. And Sonali.
Yeah, my name is Sonali Hansen, and I am the Privacy and Compliance Officer at NextPoint. I am the only one out of here that is actually based in the US and not Canada, but we do have a lot of Canadian clientele. And so this topic is very near and dear to just a lot of the business practices that we've been encountering. So I'm really hoping to kind of be able to provide some technology and e-discovery information to all of you all, but at the same time kind of learn a lot from just the discussion, because a lot of the questions that I feel like we're going to be covering are questions that I have myself. So I'm really excited for this webinar.
And Sonali, where are you currently based out of? Which city?
Yeah, so our company is headquartered in Chicago, Illinois. I'm actually in Madison, Wisconsin, because we just had a baby, so we moved a little bit outside of the city. But yeah, so primarily most of the company is out of Chicago, Illinois.
We always like to add a bit of the more fun and more personalized aspect to this webinar. So it's nice to know people in Montreal, Toronto, Madison.
Yeah.
So
well, to piggyback off that, as a language nerd, I always I grew up bilingual in English and French. So are you raising, Sonali, your baby in different languages, or is it going to be a unilingual baby?
Yeah, I'm trying. I actually speak Bengali. So same thing. I was raised in a bilingual household. But my husband does not. So he is.
That's perfect. You can have secrets with your
your
child.
He's like, I feel like you're already pitting her against me.
Exactly. My brother and his wife, my brother's wife is Chinese, and the kids who are now grown are quadrilingual. So English, French, Mandarin, and Shanghainese. So it can be done. Yeah, it can be done.
Okay, well, good to know. I'll keep trying.
Yeah.
So one of the areas that I wanted us to start with today, and I see the audience ticking up as people join us. So I'll do sort of quick summaries at certain points throughout our chat today. But there are certain pain points that are consistently coming up in multilingual litigation, and I'll ask you to each sort of provide your perspectives and. Miriam and Karina, more so from a private practice perspective, and Sonali, like even what it looks like in the context of e-discovery, and sometimes what people can experience in-house. So in now that, like I said, I'll switch it up this time around. So we'll go with Miriam first, Sonali, and then Karina, and we'll sort of do rounds just so that there's opportunities to also piggyback off of one another's backgrounds. So Miriam, if I could ask you for some common challenges that you've come across, and what are some of the best practices that you recommend to address those?
Absolutely. So in preparing for this, I thought, and it's actually the first time I've done a multilingual litigation panel. It's like my arbitration and international disputes panels is kind of roughly the same content all the time, change the specific topic. So this was a little bit from scratch. So what I did was I thought back 15 years of international disputes, like what are the cool things that happened, the terrible things that happened, everything in between. I sort of came up with a list of stuff I wanted to talk about and distilled the best practice from that. So it's really anecdotal, but I always find that's what I enjoy when I attend webinars like this, is just hearing people's personal experience rather than like some PhD thesis on best practice. So here goes. So my first example, the best practice that I have distilled is actually two for the first example. The first one is put a proviso on the record about interpretation when a witness is testifying in a different language. And I will take you to a transcript reference in a moment, like a good litigator, to tell you what I mean by that. And I'm sure those attending know the difference between interpretation and translation, but the general public doesn't, in my experience. So just to be clear, so when we're talking about interpretation, we're talking about oral. So if anyone has, you know, an interpreter, and if anyone doesn't speak English and is listening to this right now, they may have an interpreter translate. See, I just did it. Interpreting into another language, and obviously there's now there are now technological tools that automate that a little bit as well. Obviously, traditionally it was humans doing it. So when you have in a hearing witnesses testifying in a different language, often you'll have what's called simultaneous interpretation, which is also what they use at the UN, for example, and others, which is as you're talking, the interpreter, as the witness is talking, the interpreter is interpreting into the other language at the same time. They do it in teams sometimes because it's very, very intense. And if you want to give it a try, listen to a podcast on normal speed and try to interpret into your other language at the same time. You will see that it is almost impossible. So kudos to anyone who's an interpreter. But because of the very extreme conditions, right, these errors do happen quite a lot, I would have to say, or ambiguities, if not outright errors, which when we're talking about a legal proceeding and frankly, debates at the UN, is actually a potentially a big problem, right? So I'll take you to a proviso, which we developed, and I actually came up with because I couldn't find an example of anything like that as a precedent. So just kind of something to put on the record to protect yourself against errors. But less dry and more concrete, in this very case, I'm going to show you the transcript of, we had an error, or if not an error, like an ambiguity or just kind of a suboptimal choice of words that the interpreter used. In this particular language pair was Norwegian and English. So there's not a lot of from Norwegian into English interpreters who have English as their mother tongue. That's not common. So typically what you see is there are people like interpreting into their second language, right? Which means that sometimes idiomatic, like they might be strictly accurate, but sometimes the idioms and, you know, the choice of words is not perfect, and compounding that with the fact that they are doing it simultaneously. So anyway, so I'll show you an example of what the solution that we came up with for this potential problem that did materialize is have lawyers on your team, in your counsel team, who speak the language. So in this case, we had 2 Norwegian professors, so obviously, you know, almost native in English as well. And I'll show you what we did with that and how it ended up, I think, creating an extremely good advocacy opportunity for us. And obviously, as litigators, that's what we're always looking for, advocacy opportunities. So I'm going to share my screen, and I'd be grateful if someone could tell me if it's large enough, because sometimes it's a transcript, so it comes up really small.
I'll confirm. I'll be your guinea pig, Miriam.
Be the guinea pig.
And I can see it well.
Okay. So this is the transcript. So the witness is about to go to start testifying. And just for context, so this is a case involving snow crab fishing rights in the Barents Sea. The Barents Sea is in far north Norway, like at the point of Norway where it's like it's horizontal to the North Pole. Like that's how far north it is. And the whole case is in part about or at least the damages part of it, the quantity of snow crabs that were in that area, whether it was, you know, whether it was a good fishing time or a bad fishing time was a key issue in the case. And we have the local mayor, we were the claimants, so the snow crab fishing company, and it's a case before the International Center for the Settlement of Investment Disputes, ICSID, against the Kingdom of Norway. So we have the local mayor who's willing to testify for our side about all the benefits that basically our clients' operations brought to the town, and the conditions that were in place at that time. He's basically from, you know, adjacent to the North Pole, literally. So he's not someone who who even spoke English enough to get around London. It's actually uncommon this day and age to find people who really don't have any English at all, but he didn't. Even, and I'll talk about it in a little while, but even people who think they have good English, you should probably think twice before you let them testify in English. But in this case, the person actually didn't speak English. The tribunal didn't speak Norwegian. So you see the potential problem, right? It's not a case where it's like, and I'm sure Karina will talk about in a moment, like English and French in Quebec, you know, I think it would be uncommon to find a person who's gone to law school and become a judge or a lawyer who has no notion of the other language, right? That would probably be uncommon. At least they get the gist. In this situation, you know, nothing. So this is the proviso. So we're having, so the witness is at the witness table. So this is me, the highlighted part. So say we just discussed Mayor Knudsen is testifying in Norwegian. Professor Andenes will be conducting the examination in chief. So he's Norwegian professor number 1 on our team. He's doing the examination. So we don't have to be examining through an interpreter. The person, they're talking to each other in Norwegian, it's just the rest of us in the room are listening in English. Testimony is being interpreted into English, as we've heard. And I'm trying not to offend the interpreters because I know they're very skilled, very able interpreters who we thank in advance for their efforts. We've taken note of the president's cautionary word about speaking slowly, waiting for the interpretation in both directions. My understanding, and I'll be corrected if I'm incorrect, was that no members of the tribunal understand Norwegian. So it's particularly important to have confirmation that there is an audio recording being made of the testimony. So stopping there, you don't want to be in a situation where there is no record of the original testimony, and the only record you have is the transcript in English of the interpretation, because that is not necessarily an accurate rendition of what the witness said. So you want to make sure that you have the audio recording and that it's, you know, belt and suspenders, no possibility of it being deleted, like it's solid. So the secretary confirms this. I said there's no Norwegian transcript being produced. That would have been another option, to have Norwegian court reporters there transcribing the Norwegian. We didn't do that. What's going to happen is that Professor Bjorg, so Norwegian professor number 2, is going to be monitoring the interpretation as it in real time. We'll make every effort to identify immediately on the record any concerns about the interpretation in real time. Why? Because then we don't need to argue about it later, right? The impact is felt right now. If there's a problem, it's corrected immediately. Appreciating how difficult the task is of interpreting in real time simultaneously. Again, I'm really trying not to offend the interpreters. We do reserve the right, if necessary, to use the audio recording to produce a Norwegian transcript, which can then subsequently be translated if that were necessary. So of course, hearkening back to the difference between interpretation and translation, obviously, if you have the original in audio, you can have a 100% accurate transcript made of that, and then that translated into English, which of course will be accurate, and you can take all the time you need with that. So that's the proviso. So I would say I will do this again in any further future case where I have witnesses testifying in a different language, just to protect the accuracy of the information, basically. But the problem that we had foreseen actually happened. So, oh no, what's happened? Sorry, I lost my. Can you still see it?
Yeah, no, we still see it.
It just flipped on my screen as I tried to change the page. So the witness is testifying again about the quantity of snow crabs that were landing in his village at this time. And he says something which I now know is this word here, oilgiventur, and apologies for all the Norwegians on the call whose language I just mangled, which literally translates as oil adventure. And I'm sure that's what the interpreter said, oil adventure, but the person transcribing in English actually put all adventure. So it's even further from all adventure. So Professor Bjorg is listening to the Norwegian, listening to the interpretation and looking at the real-time transcript of the English. And he puts up his hands like, excuse me, all adventure is not really what the idea is. The word he used was oil adventure, which I think can only really be translated as gold rush. So imagine how happy I am sitting next to Björk that the witness just said there was a gold rush of snow crabs in a case where it's all about that, right? Was there a lot of snow crabs? Oil adventure just does not have the same ring to it. So the president, okay, well, yeah, that makes a difference. That's a substantive change. He asks the person doing the same thing on the other side, well, what do you think? Should it be oil? Should it be gold rush or oil adventure? And of course, he's like, it's better for me if it's oil adventure because nobody understands what that means. So he's trying to insist on it being oil adventure because it has nothing to do with gold. So I'm like, okay, say oil boom, oil boom, oil boom. So Björk says oil boom, and the president agrees. So we go for oil boom. So instantly the translation or the translation of this term that the witness used is oil boom and not oil adventure, which again, I think is better if you're trying to prove that there was a lot of something in a particular area. And then the president's having us like a little bit like playing Scrabble in Sanskrit in this language thing. So here's what we did with it. So the following day, our closing argument, this is mine. Okay, let's scroll down a little bit. Sorry. Why would Norway have been motivated to maintain the fishing rights if it were truly the innocent party, etc.? We heard why from Mayor Knudsen. The joint venture brought optimism again to Båtsfjord. There was light in the factory windows again. It was an oil boom of snow crabs. It was an oil adventure of snow crabs. It just doesn't have the same ring to it, right? And the same thing, my partner Pierre-Olivier later. At this point, it may be worth coming back to what was at stake for Norway. The tribunal heard the expression gold rush to describe what was happening in the fishery, and that was corrected for oil boom. And I think that either way, the idea is clear enough. Of course, Norway was well aware of this oil boom, and its Ministry of Fisheries conducted analyses, et cetera, et cetera. So that was a long way of explaining why. Firstly, I think it's important to monitor interpretation and correct it in real time. But secondly, the more nuanced point that words matter, and in litigation, we are advocates, and it's all about words, right? We conduct advocacy through words and to some degree images. And so the word choice in the testimony of witnesses testifying in different languages, whether it's interpreted oral testimony or translated written testimony, is critical. So you're going to want to work very, very closely with your language service provider, including by having lawyers, as we've seen, on your team who speak that language, to make sure that the word choice is exactly right, is consistent with your case theory, and is the best possible, like you can wordsmith it in the same way that you would in English. So that is my long-winded first and second best practice, and I will be quiet now.
No, and I really appreciate that, Miriam. And I will revert back to you for additional tips. And I even later on in the discussion talk about, can we use certain AI tools to help? Because we may not always have the luxury of having colleagues that speak a certain language. So what are avenues we could pursue? But I will pivot to Sonali to sort of give us some of the challenges and best practices she's experienced that we want to share with the team today.
Yeah, definitely. Well, to piggyback a little bit on what Miriam just mentioned in regards to words matter. So I work in the industry of more so that e-discovery, or the electronic form of all of that evidence, and finding those words or finding that information. And in regards to the multilingual aspect, there are a lot of challenges that we face with that. Oftentimes, since we're working within the US predominantly, that's our kind of primary business market. A lot of the businesses that maybe some of our counsel are representing often do business practices across multiple countries with different languages, and all of that might come into issue during the course of, let's say, collection, or even just the actual review of the information that has been collected. So a lot of what we kind of have to discuss is finding the aspects that might need those levels of translation, might need those levels of interpretation, and those elements of that. And so often, a lot of the things that we kind of have to run through is first identifying the actual sources. So if right off the bat, we know some of those sources exist in foreign countries where languages might be at issue, then we kind of take certain considerations into place. One of the most common instances is an example that I'll kind of run through here. So recently we did a collection out of China. Within that collection, it was something where they have very strict protocols when it comes to actually getting information out and making sure that it's extremely targeted in that manner. Now, the individual had actually segregated the various components that actually pertained to the litigation matter at hand. However, they were all segregated in folders that were in Chinese, and no one involved in the case spoke Chinese or had any insight into any of the characters presented. So we had to work through a translation company. Actually, Alexa was a great help in this particular situation, where we sent screenshots of all of the different custodian inboxes and all of the folder structures that existed. Now, this wasn't a standard translation in the sense that we needed the actual documents translated per se. It was more just at the initial stage of preservation, we wanted to make sure we were preserving the correct set of documents. So within that, we actually had an individual that went through and kind of formatted all of those screenshots into exactly what we were looking at, because another hurdle that we kind of faced in that situation was that the collector, even though they were doing this completely remote, couldn't identify the buttons that needed to actually be selected outside of the folders themselves. They didn't have the actual buttons and the various selections on the menu tabs, because all of that was also in Chinese. So kind of going through that entire process, making sure we were doing an identified kind of translation in a very targeted manner, because we were also trying to mitigate expenses where it was maybe not necessary. All of that arose to us finally getting the documents that we needed. And then that all stayed in cold storage until it was in a situation where it actually needed that level of interpretation or translation, utilizing whatever tools necessary at that moment in time. But I felt like it was one of those circumstances where, you always think about the translation after you have everything and you're kind of running through the documents and you realize that certain aspects have to maybe run through a machine system or an individual, but you maybe aren't necessarily thinking it through at that time of preservation, and just some of those logistical things that we came up with that we just weren't really accustomed to. So those are, a lot of that really comes down to just the level of communication between parties, and also having a level of communication with your own client, just having an understanding as to where all of that pertinent information is, and truly getting an understanding as to what some of those language barriers might be, even through the course of just that a very, very initial infancy stage of your litigation.
Thank you, Sonali. And really very different scenarios, but they each come with their own challenges. And that's just tells you how multifaceted multilingual litigation can be. Karina, I'm going to probe even further now, because you even have a certain scenario where, while I want you to share some general best practices, there's now even some changes with Bill 96 that are currently paused, and I won't say too much because you will speak to it. But the idea is that it may may have further implications on what may happen when litigation happens in Quebec specifically. So I'll ask you to sort of any general best practices and challenges, and then any sort of thoughts around Bill 96 and any effect that may have around litigation.
Thank you, Gary. So starting with the general example, as I mentioned, I run into language-related questions or in my practice in a very on a very common basis, and this is because in Quebec we have a pretty unique context in litigation, where in front of our courts, witnesses and the other participants, like the lawyers and the judges, will often be bilingual, but in some cases, witnesses will have a preference for testifying in the language of their choice, oftentimes French. And this can arise with your own witnesses. For example, if there's an expert that was retained out of Quebec and that expert is more comfortable drafting a report in French and testifying in French, that's something that for strategic reasons and is going to want to be put forward and encouraged, because you want your witness to be as comfortable and as solid as possible when they're being examined and cross-examined. So in a scenario like that, there can arise situations where the witness or the expert is going to testify in French, and you or certain key members of the team who need to listen to that testimony in real time might be more comfortable in English. So in scenarios like that, it's very important to identify any language any language needs in advance, and to identify whether there's a use case in that scenario for simultaneous interpretation. So similar to what Miriam was describing, and I've experienced this in the past in cases where the witnesses were testifying in French and the court was listening to the testimony in French, so that the interpretation was not for the benefit of the court, but it was for the benefit of a technical witness on my client side who needed to listen to that testimony and provide input as in real time. So we worked very closely to identify a service provider to assist with the simultaneous interpretation. And that comes with its own set of challenges, because in certain cases, like the one I was dealing with, it was a very complex case that involved very specialized vocabulary. It had to do with the construction of generators for electrical barrages. So as you can imagine, a lot of technical vocabulary that's not very commonly used. So there was a need to make sure that we identified the right service provider who could assist with that interpretation. And there's also a need to ensure on the logistical side that any arrangements that have to be taken with the courthouse are put in place and done so in advance, so that everything is ready once the trial is ready to go ahead. Now, on the Bill 96 side, as Gary mentioned, in Quebec, there's recently been some very extensive amendments to the Charter of the French language. And the Charter of the French language is a piece of legislation that was introduced in the 1970s with the goal of protecting the use of the French language and making sure that French language could continue to thrive, and that its use would be encouraged and maintained through Quebec society. In last year, on June 1st of 2022, very major amendment to the Charter of the French language was adopted. This is what we often refer to as Bill 96. And the goal of Bill 96 was basically to update the charter and to strengthen the requirements for the use of French in pretty much all aspects of society. So it deals with everything from the workplace, and requirements about the use of French in the workplace, instruction, going to school, communication, commerce, business, and also justice. And with respect to justice, there was a very specific requirement introduced that legal pleadings filed by corporations would have to be in French, or if they were in English, would have to have an English translation. If they were in English, they would need to have a French certified translation attached to them. And if the pleading doesn't respect these requirements, then the clerks at the courthouse would have to refuse it and not accept it. So obviously this has very big implications in terms of the preparation that's required before of filing can take place. Now, these requirements were supposed to go into effect on September 1st, 2022. They're currently suspended as a result of a constitutional challenge that was brought to these requirements that is still pending before Quebec courts. So we're still awaiting the final outcome of that decision. And right now, those requirements are not in effect, but we are all considering and thinking about best practices in terms of how to facilitate compliance if and when they do have to go into effect. And there, I think the key decision point that is going to need to be considered is whether or not the filing is going to happen in French, or whether it's going to happen in English with a French translation attached. And I think a key element that's going to play into and feed into that decision is going to be, is it the kind of pleading that requires an affidavit in support of it and somebody to attest to the truth of the facts that are alleged in that pleading? Because in that case, if the English is, for example, if the witness is an English speaker, then that's going to probably drive a decision to have the pleading in English. And if that's the case, then the time required to have the French translation prepared is going to need to be factored in the preparation for filing.
Thank you, Corina. And I know that's a big topic. So the court challenge is certainly buying some time for the legal community, so as they think through what it'll look like if it proceeds as is. So, Miriam, I will come back to you, and I will try to build in a question from Shehu as part of it. It's I may even jump in on it myself at one point afterwards, because I used to be a court interpreter. Part of the reason how I ended up in translation previous to my lawyer life, and I've been in a situation similar to what's being described. So let me just read the question for the audience, and then Miriam, I'll ask you to speak to it first. And beyond this, obviously, if there were any sort of others best practices that you would add, we can do it at the same time. So the question is, to protect the credibility of testimony, it is increasingly becoming better practice for lawyers to take a back seat in the preparation of witness testimony, at least in the wordsmithing of it. So to what extent is an interpreter required to be neutral in such multilingual proceedings? And do any of the panelists think that having a single interpreter, perhaps appointed jointly or by the adjudicator, will assist with the credibility and integrity of the proceedings?
So should I start? I'd actually like to incorporate that, because I want to keep a bit of a, and thank you for Shehu for the question and for coming. Because I don't want to derail off the best practices tidbits, and then I think that's a good that's a good question and a good example to feed into that. So the next best practice I wanted to talk about is the one that Gary paid me a lot of money to say, but it's okay because I happen to agree with it. I'm just kidding. Which is integrate your language service provider and or your translator, if you work with them, directly into your team as quickly as possible, as early as possible, in cases that involve foreign language or different language testimony documents. I have so many examples of why this is important, but I'd like to highlight two and then get to Shehu's question. So the first one is Sergei Tsivunin, who is here. Thank you for coming, Sergei. And I have worked on a great deal of, so Sergei is a very, very experienced, well-known Russian and English interpreter, and French, I think, also interpreter and translator in Toronto. If he were on screen, he'd be turning very red. He deserves the accolades. Yay, Sergei. Sergei and I have worked together on probably 7 or 8, I would say, different cases over the years that involve Russian, which does not happen to be a language that I speak. So I mean, especially in that context, right? Like, again, in the Canadian context, English and French, I think in general, the lawyers involved, especially in Quebec, can manage both languages. So it's a question of getting it done. You're not as dependent, right, on your LSP or on your translator. If you don't speak, Sergei says he's turning red. I can imagine. If you don't speak the language, you're even more dependent on them, right? So even more important to find people like Sergei, now I'm going to mention you like every sentence, just so I can see how much I can embarrass you. So you can integrate them into your team and really trust that they're really part of your team and are doing everything they can to assist you with the case. So I have a few examples of that particular thing involving Russian, and why that was important to kind of integrate Sergey early versus just kind of getting everything done and then hoping for the best with the translations at the end. One of them, again, on the topic of law is language, right? Law is language. We don't write law right now anyway in code. I mean, maybe in the future we will, but for now we write it in language. And witnesses talk about what happened in language as well, right? So they're so closely intertwined. Even more so in this particular example. So it's a really very, very large, one of the largest cases involving the Russian government and Russian constitutional law, of which I am not an expert, you may be surprised to learn. And there were a lot of issues, but one of the narrow issues was the meaning and scope of the word zakon, which I understand means law. Just like in English, actually, if you say the word law, it could mean the concept of law, law school, you know, writ large, or it can mean a particular law, right? And perhaps the grammatical and the context and the syntax of a sentence could tell you which was intended in any given particular circumstance. And so this particular case involved whether in a provision of the Russian Constitution, the use of that word meant law writ large or specific, okay? So we have a Russian constitutional law professor draft an opinion on the matter, and he thinks he can do it in English. So he writes it in English. We get it. We're like, oh, no, just no, not a good idea. So he writes it in Russian, but then we had to do the translation in English, and that is not there was zero room for ambiguity, right? Even writing it in English, these are very specific concepts and very difficult concepts. So Sergey became involved in helping to draft the original, to draft the translation and so on. So very, very integrated into the team, in other words. Not like, oh, we're going to do the whole thing and then you're going to come in after and translate it. Another example involving that same witness and Sergey, preparing him for being cross-examined. Again, he thinks he can be cross-examined in English. We say, no, you cannot under any circumstances, because no, it's just not going to work. And so Sergey was involved in the witness preparation process, like from the whole time. And then at the plan for the actual cross-examination, which was going to be out of court, a bit like a US deposition, we had planned to have the official, so to speak, interpreter, but also Sergey interpreting for us. So playing a bit the role that Professor Bjork was playing in the other case, just monitoring the official interpretation to make sure that it's accurate. So Sergey, I'm done with you. I hope you're happy. You can pay me after too. The other example that I have to give is Alexa to the rescue. It's kind of a broader point about caveat emptor. You get what you pay for, which I learned, I guess, a little bit, like many of us do, a little bit too late in my career. So we had in a case involving thousands of Spanish documents into English, I thought it would be a good idea to hire a bottom feeder translation company to do those. And of course they came back, it was just a disaster, like incomprehensible in many cases, not the kind of thing I mean, today's machine translation does a way better job than what these people produced, even if you don't edit it. And so Gary and team very graciously stepped in at the last minute and got it all redone. But obviously there's a cost to that, and it's no, you're making people work under very tight and extreme circumstances, which is not ideal. There's not time to really think about terminology and so on and so forth. So one example that comes to mind, in addition to the fact that they were generally very difficult to understand, for saneamiento, which is like an administrative law concept in Latin America and under many administrative codes. which is, we would say cure. So you cure a defect in a resolution, for example. They put sanitize, like sanitation. So it's just like, what? We didn't even know what they meant. We couldn't even understand what they were trying to say about it, right? It's not even that it was inelegance. You couldn't even understand what they were trying to say. So thank you to Alexa for stepping in on that, and you get what you pay for. So Shehu, there we go. I think, hi Katya. Katya, wonderful into Spanish translator who would not have let this happen. What was I going to say? To your question, Shehu, about being hands off. So anyone who follows this topic more generally about witness preparation and written witness evidence and preparing witnesses will have a lot to say about the matter. It's controversial and it's cultural, legal cultural, in the sense that different legal cultures have different approaches to the matter. In Canada and the US, the thought of allowing a witness to just do what they want without our having extensively prepared them makes us want to vomit. Whereas in other countries, it's an ethical breach to do that. So I think it's it depends. I do think, kind of from the camp of wanting to prepare the witness as much as possible, including on the language side, not only is it about, it's not so much about wordsmith. So the wordsmithing is one thing, but I think the bigger thing is helping them tell the story in a coherent, punchy way that doesn't take 3 days. So we don't have 3 days to sit there and listen to the story in a way that a witness might have wanted to tell it. We're the ones who know what are the key issues, and often the key issues in a case are not necessarily the same as what the witness thinks are the key issues in the case as they lived it, right? So I do think I think if we move to a system where witnesses are not prepared, hearings and trials will take a whole lot longer, and everybody will be very frustrated because it'll be kind of, Karina agrees. I think it's important to help distill that. So but others will have a different view. Barristers from the UK, for example, would have a different view. People from civilian traditions would have a different view, and there's not even much of a witness evidence culture anyway. So I think that's what I had to say about that.
Thank you, Miriam, and that is very good advice. Having been a court interpreter, I can tell you that I do see a lot of value in preparation, and it's even, frankly, some of the terminology and wrapping the mind gives the interpreter an opportunity to think through some of the terminology they should use as well while they're live, so to speak. So that it is a good opportunity. And there can be enough caveats given that obviously everything has to be truthful, etc. But having the discussion focus can ultimately be in the client's interest, because time spent, as we know, lawyers typically bill by the hour. So the more time is being spent, the more costly it is for the clients. Sonali, I do want to pivot quickly to you, just because when we think of the role technology plays these days, and you're dealing sometimes with cases that can involve thousands of documents, so very, very large volumes of documents. So what role are you seeing technology play, and what are some of the avenues that, when you think of sort of your own clients, piece of advice you would have in saying, here's how you can employ technology to really help narrow down focus on certain documents? Just on mute, Sonali. So
I realized I was on mute. Yep. No, thank you for that question. It's funny that you say thousands. Honestly, I feel like as of late, it's become millions, and millions is what's standard now. Which when I started, that was so far few in between. So it's crazy how quickly that has escalated. But with those millions, I mean, you're working on tight court deadlines, you're working across, the circumstances that we're talking about here with the multilingual factors and documents being in other languages, and maybe not having the staff that can appropriately view all of those documents in a timely fashion and in an accurate and precise way. So a lot of what the industry, I think, is starting to migrate into is just the usage of artificial intelligence. It's just become a little bit more of a no-brainer, because with the amount of evidence that has to be, I'll use Miriam's term, distilled, kind of the same way that you were talking through from a witness standpoint, the same goes for just the amount of information that I think comes with all of those witnesses. And distilling that in kind of a comprehensive, accurate, and precise manner, machines just have really come into play with all of that. And so the primary usage that I've been noticing, especially when it comes to if you have the language elements to it, not only are you trying to identify the documentation that maybe pertain to the various languages that are at issue for a particular litigation, because there's maybe multiple, and you have to go through and you have to identify where those actually exist in a pool of millions upon millions of documents where there might be a lot of other varying documentation involved as well. But then on top of that, you're also dealing with just a lot of the privacy and confidentiality considerations for the various sectors. So kind of going back to that Chinese example that I was using, China has very strict guidelines as to personal identifiable information, as does the UK. There are a lot of other countries that are kind of adopting those very strict data privacy regulations. Now, with that and getting all of those resources, that artificial intelligence can automatically bifurcate not only where maybe some of the multilingual elements exist, but then on top of that, where the personal identifiable information exists within those documents. So a lot of that is that's where I feel like the industry is kind of starting to defer to. So outside of just your standard assistance when it comes to review and getting that information filtered down into what's actually relevant and targeted for your case, beyond just the usage of AI for that, it's really starting to be utilized more so in some of this categorization and filtration techniques when it comes to just those data privacy laws and some of the language elements that are involved as well. So I do really feel like, outside of just talking about AI as a whole, I feel like the predictive coding element of things, which I feel like is something that maybe a lot of attorneys are becoming more and more familiar with, that kind of goes into more of that review element. And while that is extremely valuable, I do think it's really important to start kind of considering AI even from some of these other facets as well.
Thank you very much, Sonali. Really helpful background to have, and certainly not too many lawyers, frankly, not too many people in the practice of law in any aspect deal with millions of documents. So that's certainly a perspective to bring at a very different level. Karina, I just wanted you to have an opportunity because as timing is tight, I have one more question to the group, but just wanted to see if to circle back and see if there was anything else you wanted to add before I go to my last question.
No, you can go ahead with your last question.
Perfect. Thanks, Karina. And the last question, and obviously pending any other comments that you may have, we're seeing AI in translation become higher and higher quality, and some of the areas are, and I brought this point up earlier a little bit when Miriam was saying, try to have a lawyer that speaks the language, and it's a luxury that sometimes you don't have, like the example you had, Miriam, and you had Sergey involved. Now, as having been on the translation side as well as a lawyer, I cannot emphasize enough how important it is to include the linguists that are supporting in the process from the very beginning. Give them as much background as possible, because if you're expecting the linguists to work in a vacuum, they're only working with very limited information without understanding the bigger picture. And sometimes just the example of law, is it referring to a law or law in general as a concept, as natural law, or whatever the context may be. So on that note, as we see, whether it's a large volume, like Sonali was referring to, thousands or millions of documents being reviewed, whether it is to double check on a document, what do we see as the role of AI in translation? Do we think that that can help more and bridge the gap in this? And I'll open it to any of you, because I have some thoughts as well, but it's really more about your thoughts.
This will be the topic of the next webinar. We can't possibly cover this topic in 6 minutes.
We can try.
I know I have a lot of thoughts about it, but I'd invite Sonali or Karina to step in if you want.
go, Miriam, and then we'll circle back again. So.
So I think it's okay. One of the criticisms and I wish Eliza Graham is here, who's a Spanish and Portuguese into English a translator I work with a lot, and we have conversations about this all the time. It's important, I think, when we talk about AI machine translation to identify what exactly we're talking about and use, because I think that changes everything. Because some people say, oh, AI is terrible, it's going to take all the jobs, or AI is not just in language services, like in everything. And AI translation is terrible, or it's really great, or whatever. But I think it's really important to parse out what we're talking about. So the way I think about it, there's various use cases, and obviously there's also various products. So let's put the products aside for a second, because that's too complex. Just the standard product that does a great job. Alexa's product, there are others. DeepL is one that I use a lot. For legal, it does quite well. Are you going to use it? Are you just going to feed documents into it and use them as is? Or are you going to use it as a tool for your translators to use or for yourself to use? That is totally different, right? That is totally different. It's like the difference between feeding in your invoices and having a machine do your taxes for you versus your accountant does your taxes using software. Like, that's not the same thing. So the way I use it, wearing my translator hat, is I use it extensively myself as a tool for myself, for my team, right? Which increases efficiency incredibly. And I think kind of as translators, if we're not using it, it's, you're not using the state of the art. Feeding documents into the tools that we have today and then not editing them, I don't think we're there yet for many use cases that are official. Like, I wouldn't give them to an arbitral tribunal or a judge as is. I wouldn't close a deal on the basis of that. I think it does great just for knowing what it is, knowing whether you want to then get a translation of the document, for example, or just using it inside the office. It depends what the document is. Like, data protection agreements under the GDPR in Europe. I mean, these products have seen literally millions of examples of that. So they produce a very, very good draft. Supreme Court decisions of the French Cour de Cassation, no, right? It depends what the document is, depends what you want to do with it. What actually when we did the second filing in the case that we did with Alexa, where they saved it on the first filing, we tried to be more proactive on the second filing, and this was a few years ago even, so the AI was not what it is today. We had a categorization system for each document, whether it was a core document, as in we're going to bring it specifically to the tribunal's attention in our pleadings or in the hearing. At the other end of the spectrum, whether it's a document we have to file just because, but nobody cares, and somewhere in the middle. So Alexa did the number ones, the really important ones. We had, this was Spanish English. We had a less expensive company in Latin America where the translators were not native English speakers translating into English for category number 2, like the middle ground. So a little bit less expensive because they were a little bit less important. And then we did barely edited machine translation for number 3, which were documents we didn't really care. So I think just look at your use case and make decisions accordingly is the best practice.
Thank you, Miriam. Really appreciate that background, and feel free, Corina or Sonali, to jump with any last thoughts. Genevieve brought up the question of confidentiality in the use of AI, and if I could summarize sort of my advice on that is, any tool that is free or inexpensive, confidentiality is an issue most likely, because typically, as they will say in the world of technologies, if it's free or inexpensive, you are the product. Typically, they're using your data for the training. So you have to make sure that you have sort of the right support in the process, and that the provider is truly providing a confidential product. And
there's just to that note, I mean, that's something that I deal with on the regular, and I think it's just really important to make sure that whatever relationship you move it towards with whatever company that you decide to kind of partner with in that situation, if there's certain considerations that you utilize, such as non-disclosure agreements and things internally with just any standard vendor that should apply in that exact same circumstance. So make sure kind of you're utilizing the same business practice, even if it's for the usage of AI. Sometimes that's an oversight.
No, thank you, Sonali. Really appreciate that background. So again, the audience, you feel free to reach out to any of our panelists offline, and there will certainly be a continuity to this because we're just scratching the surface. There are so many subtopics that could come from this. I appreciate all your time, and thank you again for joining us here today. You will receive an email with a summary as well as a link to watch this offline. And thank you to my panelists today. This was a great session.
Thank you.
Thank you.
Thanks to everyone who came.